Hello and welcome to the Children's Commission 87th Legislative Session Update. My name is Jamie Bernstein and I am proud to serve as the Executive Director of the Supreme Court of Texas Children's Commission. This webcast is presented live in July 2021 and reflects bills that passed during the 87th regular session. If other bills pass during the current or future special sessions, we will release additional information at a later date. For attendees who are not familiar with the Children's Commission, we have a mission to strengthen courts and thereby improve safety, permanency, and well-being outcomes for children and families in the Texas child welfare system. I'm joined today by Dylan Mensch, Legal Representation Director, and Amy Corbin, Staff Attorney at the Children's Commission. We will alternate updates about CPS-related bills. A housekeeping announcement. We will archive this video for this presentation. The PowerPoint and the written legislative update will all be distributed in early August. CLE is pending for this webcast, and we will follow up with details about CLE if it is approved by the State Bar. Thank you for your patience. Next slide, please. We've broken down this legislative update into subject matter areas. Dylan will cover the majority of the first hour with legal procedures from pre-removal to post-final order. Then he'll cover suits affecting the parent-child relationship issues. I will round out the hour with information impacting youth and young adults. Amy will address topical issues that she focuses on here at the Children's Commission, including human trafficking and education. Dylan will then cover other topical issues, licensing and placement. I will conclude the second hour with administrative concerns, including community-based care. We will reserve time at the end to address any questions that you may have. Please use the Q&A feature. Include in your question who it's directed to and the bill number if applicable. If you're watching on YouTube or at a later date, please direct questions to children@txcourts.gov and we will respond as soon as we can. In addition to being a state and national expert on legal representation, Dylan also tracks legislation at the Children's Commission. I want to thank him, Amy, and our exceptional Children's Commission staff for making this presentation possible. I'll now turn it over to Dylan to get us started.
Thank you, Jamie. And I also just wanted to thank our legal intern, Kayla Tabuena, who also helped a lot with tracking legislative bills this session. And as you can see, this was a very, very busy legislative session, especially when it came to child welfare. We saw a lot more bills related to child welfare filed than we did in the 86th legislative session, and a lot more bills passed. So 58 bills passed this session that were directly related to child welfare compared to 43 last session. It's also important to note that not only did more bills pass, but a lot of these bills were more directly related to child welfare representation and legal procedure and had more substantial changes than in previous sessions. And the first bill that I want to talk about, that's the one I'm guessing is on many people's minds, is House Bill 567. This bill made some very substantial changes to a lot of the legal procedures related to CPS cases. So I'm going to spend some time kind of covering all of the sections of this bill in depth. So the first section of the bill affected Family Code section 107003 and 107004. And what it did is extended some of the duties of the attorney ad litem of a child to suits that were filed under Chapter 264. Now, Chapter 264 is the chapter that includes the court-ordered services statute, or oftentimes referred as the motion to participate statute. That statute is enhanced by 567, which we'll talk about a little bit later. But this amendment extends those duties of the attorney ad litem to meet with the child before each hearing, as well as other statutory duties. They had previously only applied to suits under 262 and 263. Those duties have now been expanded to suits under Chapter 264. The next section of the bill affected Family Code section 101001. And this addressed the list of enumerated circumstances that were passed in the 85th legislative session that were deemed insufficient circumstances that would justify a termination of parental rights. When that language was initially added, it prohibited a court from making findings based on those circumstances. That language was, there were concerned that that language may have been problematic and may have restricted courts from considering certain evidence or would require courts to rule out evidence. So that language was updated so that now, instead, those circumstances are simply listed as evidence that does not constitute clear and convincing evidence justifying termination. So the list stays the same, but it's slightly differently phrased how courts are supposed to interpret that list. It also adds to that list of legally insufficient circumstances, allowing a child to engage in independent activities. So that list of legally insufficient circumstances has been altered, and there'll be some few bills later on that we'll talk about that also add to that list of legally insufficient circumstances. Importantly, those changes to how the courts view that list applies only to petitions and motions that are filed on or after September 1st of this year. Moving on to Section 4 of the bill, this bill clarifies that a motion or petition filed by the Department of Family and Protective Services for termination of parental rights is subject to Chapter 13 of the Civil Practice and Remedies Code, as well as Rule 13 of the Rules of Civil Procedure. And I want to explain this provision a little bit because I know there's been some questions about it. This does not actually change the law, and the reason why it doesn't is because those chapters and those rules have always applied to suits filed by DFPS. This was inserted really as a statement of emphasis, simply to remind us all that they do in fact apply. And what are these provisions? These provisions simply state that each factual allegation or contention in a motion for pleading has to have evidentiary support or is likely to have evidentiary support after a reasonable investigation. Likewise, the Rule of Civil Procedure just reminds us that when an attorney signs a pleading, it constitutes a certificate to the best of that attorney's knowledge that those pleadings are not groundless and they're not made in bad faith and they are not brought for an improper purpose. So while this does not actually change the law, it is intended to change some practice. For those jurisdictions that had a practice of pleading all of the termination grounds, sort of irrespective of what the facts of the case are, this is intended to change that practice. But importantly, it does not actually change the law. It just emphasizes that this law does in fact apply to suits filed by DFPS. The next changes by the bill are in Section 261.001. And this is another section that you may have heard about because it changes the statutory definition of neglect. It adds that a person's acts or omissions must now evidence blatant disregard for the consequences of those acts or inactions that result in harm or immediate danger to the child's physical health or safety. So that blatant disregard adds a new element that's taken to a mental state that is required to meet the definition of neglect. Instead of defining neglect as conduct that resulted in a substantial risk, conduct must now constitute an immediate danger to the child to meet the definition of neglect. It also adds to the definition of activities that do not constitute neglect, allowing a child to engage in age-appropriate activities. I also want to emphasize that immediate danger has always been required in the statutes for emergency removal, both with an affidavit and in exigent circumstances, and in the adversary hearing confirming that removal. So this new definition of neglect is going to have a lot of impact at other stages of the case, particularly regarding mandatory reporting and investigations of abuse and neglect. Those statutes will have to factor in this new definition of neglect when people report cases of abuse and neglect and when those cases are investigated. Moving on to Section 6 of the bill, this amended Chapter 262.116a. This is again the list of legally insufficient circumstances that are not sufficient for removal. So it amends that list and adds two activities to that list. It allows allowing a child to engage in independent activities to that list that is insufficient for removal. It also adds a parent's positive test for marijuana to that list of legally insufficient circumstances, unless the parent's marijuana use caused significant impairment to the child's physical or mental health or emotional development. Moving on to Section 7, this section makes several changes to Section 262.01, the adversary hearing statute. And what these changes do is they really sort of clarify the procedure of what a court must find regarding a parent who is not involved in the circumstances for removal. There had always been a little bit of ambiguity about how those Findings had to be made regarding both sets of parents. There was a provision ground N that required placement with a non-offending parent unless it was not in the child's best interest. That's now sort of been removed and clarified, and a specific procedure has been set out regarding parents who are not involved in the circumstances of removal. Now, the court must specifically place the child with that parent unless the parent cannot be located, or the court finds that possession of the child by that parent constitutes a continuing danger despite reasonable efforts by DFPS to enable that parent's possession. If the parent is then located by DFPS after the adversary hearing and that parent makes a written request for possession, DFPS has to notify the court and has to request a hearing. Additionally, at each permanency hearing, before a final order, these are changes that were made to Family Code Section 263.002. The court has to return the child to the parent unless the court finds a continuing danger to the physical health and safety of the child, and that returning the child to the parent is contrary to the child's welfare. It's very important that these findings are made as a conjunctive, meaning you need both of those findings or the child must be returned. So simply stating that it is contrary to the child's welfare to return to the parent is not enough. The court must also find there is a continuing danger to their physical health and safety. The bill does specify that this does not impact the court's ability to order a monitored return under Section 263.403. So if the court does order the return of the child to the parent, they don't necessarily have to dismiss the case. They can order a monitored return or a transition monitored return under Section 263.403. Moving on to Section 9 of the bill, which makes changes to Section 263.401. This requires courts now to make a finding of extraordinary circumstances and extend the dismissal date if the parent has made a good faith effort to complete the service plan but simply needs more time, and the court intends to return the child once the plan is completed. These are circumstances where the extension of the deadline was probably being granted, but now it is codified that it is required to be granted in these circumstances. Moving on to Section 10 of the bill, this affects 263.401. And this section was intended to address a circumstance where some courts were sort of getting around the statutory deadline by commencing a trial on the merits and then sort of recessing that trial indefinitely to effectively allow the case to continue to be extended and that case to continue to be worked beyond the statutory deadline. So now, a trial on the merits, once it is commenced, a court has to render a final order within 90 days with no tolling for any recesses. A party may file a mandamus proceeding to compel compliance if a court is not proceeding towards a final order within this timeline. A court is allowed to grant one good cause extension, but they have to specify the specific good cause for extending the length of time, and they have to specify the specific length of time in the extension. Section 11 of the bill modifies 263.403A1, and this is the section of the bill, again, that was came out of the 85th legislative session that added a transition monitored return in addition to the regular monitored return. That language also allowed an additional 6 months under a monitored return to complete the services. And this language simply clarifies that that additional 6 months applies specifically to the transition monitored return because it is intended to allow time to complete the services that are specified in that transition monitored return order. Moving on to Section 12 of the bill, this bill modifies the court-ordered services statute that we mentioned earlier. That statute has been around for a long time. It is also referred to as the motion to participate statute, but that statute didn't have a lot of sort of clear and robust procedures as to how petitions should be filed, when hearings should be held, and how long suits could last. So this bill really changes all of that and really builds out a lot of due process and clarity in how these cases are supposed to proceed. So this bill makes changes so that DFPS has to file a suit in a jurisdiction where the child is located, and that petition has to be accompanied by an affidavit that states facts sufficient for the court to make the required findings that the court has to make to confirm the legal proceeding. The court has to hold a hearing on the case within 14 days of filing the petition and may grant a 14-day extension for good cause, and during that time may render temporary restraining orders under Section 105.001 for the safety of the child. Importantly, the bill also requires appointments of attorneys for parents and for children when the petition is filed. And this results in sort of an interesting dichotomy where parents in court-ordered services cases will now be appointed attorneys earlier than parents who are in a TMC case where removal has been affected, because those parents are not entitled to an attorney until they appear at the adversary hearing and request a lawyer and confirm indigency. However, if a parent is appointed this early representation in a court-ordered services case and they are subsequently not found indigent, that attorney will be dismissed at that 14-day hearing, and the court must order the parent to pay the cost of the attorney's services up till that point. The court, once it receives the petition, must reject it unless it can make findings under the ordinary prudence and caution standard that abuse and neglect has occurred, or that there is substantial risk of abuse or neglect or continuing danger, and that services are necessary to ensure the physical health and safety of the child. It requires that services must be narrowly tailored to the court's findings, and importantly, they may only apply to the perpetrator of alleged abuse and neglect. The previous version of the statute allowed those services or those ordered to complete services to apply to anyone in the household. The court has to review the order within 90 days, and that order automatically expires within 180 days unless it's extended by the court. So this sets up sort of a natural expected deadline of court-ordered services cases of about 6 months. The court may extend that order for 180 days to about 12 months upon a showing by DFPS of a continuing need for the order, and that may extend another 180 days to 18 months, but only if the court finds that that extension is necessary to complete the services ordered. DFPS made a good faith effort to provide services, and the parent made a good faith effort to complete services. And also, they must find that completing services is necessary to ensure the child's safety, and importantly, the extension must be requested by the parent or their attorney. So all of those elements have to be in place to get that final 18-month extension. House Bill 567 also repealed Section 263.113 and 263.1131, as well as the provisions in the adversary hearing statute that establish the procedure for a non-emergency removal. So the non-emergency removal provisions under Chapter 262 have now been entirely removed. And I think it's very important to kind of view that in the context of the additional due processes and legal representation that's built into the court-ordered services statute. I don't think you can kind of view one without the other. It's clear that the legislator intended to kind of affect a more robust procedure for cases that were non-emergency removals, but sort of apply this new court-ordered procedure to those cases. Moving on to legal procedures in CPS cases that were outside of House Bill 567. We sort of divided these bills and their effectiveness into different stages of the case. And the first bills that I want to talk about are bills that affect sort of the pre-removal stage of a CPS case. And the first bill I want to talk about is House Bill 3379. It has an effective date of September 1st of this year, and it affects Section 261.001, and that's the mandatory reporter statute. And what it does is it sort of raises the level of cause that a person has to have before they are required to make a mandatory report. A person must now have reasonable cause to believe a child is being abused or neglected, not merely any cause to believe a child is abused or neglected. These changes apply to reports that are made after September 1st of this year. Moving on to House Bill 135, that's effective September 1st of this year. This affected Family Code Sections 261.3027 and 261.3091. And this bill was part of several bills that were filed this session that were concerned about information about a parent's rights being provided to a parent upon their first contact with DFPS in an investigation. This was the only bill addressing this particular issue that made it all the way to become law. And what it does is it requires a CPS investigator to inform an alleged perpetrator of abuse or neglect of their right to make an audio or video recording of that interview. They also have to inform the person that that recording is subject to subpoena, so it may come into evidence later. And the investigator has to document that notice of this right was provided to the parent. And there's pretty serious levels of documentation that are required. DFPS has to have the parent sign 2 copies of this notice, one to be given to the parent, one to be retained by DFPS, and DFPS must retain that other copy in their case file. Importantly, before conducting the interview, DFPS must also notify the person in writing that they can request an administrative review of any findings DFPS makes regarding the investigation. And again, the person has to sign acknowledgement of the receipt of this information. Moving on to House Bill 2536. This is a bill that was effective immediately upon a signature by the governor, and it was signed, I think, before the legislative session even ended. So this is effective as of now, and it amended Family Code sections 161, as well as 261 and 262. And again, this addressed those list of legally insufficient reasons for removal and termination. And it adds to that list seeking a second opinion of a child's medical care or transferring medical care of a child to a new provider or a facility to those lists of legally insufficient reasons for removal or termination. It also excludes those same activities from the definition of neglect. There is a little bit of an interesting issue with the effective date of this bill. As we talked about earlier with House Bill 567, that changed the way courts are supposed to sort of view the legally insufficient reasons for termination. But House Bill 567 doesn't become effective until September 1st of this year, whereas this bill is effective right now. So this addition to this list of these legally insufficient reasons is going to be sort of judged under the previous standard of viewing this evidence until September 1st, and then will also be judged by the new way of viewing this evidence once September 1st happens. Moving on to House Bill 3041. This bill creates a Family Preservation Services pilot program and establishes an entirely new procedure under Chapter 262 that sort of articulates this program. This will only apply to certain regions where this pilot is implemented, so this won't apply to everyone. But we wanted to let everyone know about this bill because I think it's a good indication of sort of where the legislature's mind is about how to sort of modify and improve DFPS procedures. So what this pilot program does is it allows DFPS to dispose of an investigation by allowing a child who is a candidate for foster care to return home and provide some time-limited family preservation services that qualify for federal reimbursement under the Family First Prevention Services Act to children who are candidates for foster care or pregnant or parenting youth. Importantly, the bill also defines candidate for foster care as a child who is at imminent risk of being removed due to a continuing danger to the child's physical health or safety, but for whom a court has issued an order allowing the child to safely remain in the home or a kinship placement. And that's important because being the subject of a court order is included in this definition of being a candidate for foster care. It's also important to note that changes in this law apply to suits filed on or after September 1st of this year. So the pilot program must be implemented in one rural jurisdiction and in at least one urban jurisdiction. It also has to be implemented in one jurisdiction that has implemented community-based care. But while these services are being established, the child safety still has to be the primary concern in authorizing these services. The bill also requires DFPS to use Title IV funds to pay for legal representation that's provided in these cases, or provide counties a matching reimbursement for the cost of providing legal representation. And they also must use TANF to provide funds for in-home support services. DFPS, as we said before, they must obtain a court order to compel the family of a candidate for foster care to participate in these services, but a court order is not required to provide services to pregnanting or parenting youth in foster care. Now, the legal procedure that is set out under this pilot program is very, very similar to the legal procedure for the court-ordered services cases that is established by 567. But there are some changes that I wanted to go over that are a little bit enhanced. A lot of those have to deal with connecting the services to the risk to the child. So the petition in these pilot program cases has to include a safety risk assessment that documents the process for the child to remain safely in the home with appropriate family preservation services. It has to document the specific reason the DFPS should provide the services and connect the services to how they will mitigate the risk to the child. The court may order services for a parent whose rights to another child were previously terminated. And if the court finds clear and convincing evidence that aggravated circumstance exists, the court may order services not be provided and the case can be excluded from the pilot. The family preservation plan specifically has to be developed with the family, and it has to be written in a manner that is understandable to the parent and in a language that the parent understands. That plan has to include a safety risk assessment, has to include the reasons for DFPS involvement, and it has to be narrowly tailored to address the concerns that are present. It also has to list the specific services the family will receive. It has to state the manner by which those services will mitigate the risk factors, specify the task that the family has to complete, and include any contact information for the DFPS or single source continuing contractor who will be the point of contact for the family working these cases. The family is required to sign this plan. However, DFPS still must submit the plan, even if the family does not sign and they refuse to sign that plan. Importantly, a parent can choose to obtain services from another provider of their own selection, but if they choose to do so, they are responsible for the cost of those services, and the services provided have to be similar in scope and duration to the services that are in the service plan, and the provider has to certify that the parent has in fact completed those services. DFPS may contract for services, and in regions that have community-based care, they can contract with the single source continuum contractor to provide those services directly. Performance measures for evaluating this pilot include fewer children entering foster care in the pilot program region, fewer children who were removed after receiving services, fewer children who enter foster care 5 years after receiving services, and that has to be compared to other regions of the state. Courts that order services that do not qualify for federal Family First Prevention Services funding must identify an alternate method of financing those services, and specifically who will pay for those services if they don't qualify for FFPSA. DFPS will have to provide reports to the appropriate committees of the legislature 1 year after the pilot program is established and every 2 years thereafter. Those reports have to include actions taken by DFPS to ensure that the pilot is successful. They have to analyze the role of the courts and legal representatives, as well as child protective investigations, DFPS, and single source continuing contractors. The reports must include analysis of any barriers to successful implementation of the program. It must include recommendations for overcoming those barriers. It must include data on performance-based outcomes and outcomes compared to other DFPS regions, and recommendations regarding how the pilot program should be expanded, if it should be expanded. House Bill 3041 also contains some other provisions that apply to all cases, not just cases in this proposed pilot program. It modified Family Code Section 263-202 on the status hearing that requires that the plan must be narrowly tailored, not reasonably tailored to address issues. And we've seen that narrowly tailored language appear a lot in a lot of the updates this session. It also requires DFPS to provide information to relatives in writing, and that information must include the ability and the requirements to participate in the care and placement of the child, as well as deadlines, timelines, and procedures of a SAPSR case filed under Chapter 262. So really trying to get more information about how relatives can be involved and how the procedures work at the very beginning of the case. It also adds a provision to the court-ordered services statute that allows people in a general court-ordered services case, not just the pilot, to obtain services from a provider of their own choosing. But again, they still must be responsible for the cost of those services. The provider must certify that the parent completed services, and DFPS has to accept the provider's verification as proof of completion. All right, moving on to Senate Bill 1578. This was a bill that's effective September 1st of this year. It affected Family Code Sections 261, 30117. And really the concern of this bill was addressing any perceived conflicts of interest for doctors who either report abuse and neglect or who work very closely with DFPS on identifying abuse and neglect. So the provisions of this bill allow DFPS or the child's primary care physician or their parent or legal guardian to request a specialty consultation. DFPS then has to refer the case to a specialty consultation with a board-certified physician who was not involved in the reported abuse and neglect. So before that consultation, DFPS has to provide notice to the parent of the name, contact information, and credentials of the specialist. That parent can then object to that specialist if they choose to and propose a referral to another specialist. If the parent and DFPS cannot agree to a specialist after collaborating in good faith, which they are required to do, DFPS can still refer that child's case to the specialist over the objection of the parent or the legal guardian, but the parent may still seek a second opinion, and DFPS must consider that second opinion and document its analysis of that second opinion requested by the parent. Continuing with Senate Bill 1578, it also affected sections 261.30175 and 261.504, and it requires a healthcare practitioner who reported suspected abuse or neglect may not provide a forensic assessment services in connection with that investigation. DFPS must refer the case to a practitioner for forensic services that was not involved in the reported suspected abuse or neglect. DFPS can still interview that original healthcare practitioner in their capacity as a principal or collateral source of information. They just can't provide forensic analysis. Courts can also specifically consider a medical opinion from a professional obtained by someone who has a protective order against them when the court is making findings about whether or not a child has been a victim of abuse or neglect. Continuing with 1578, it also amends Chapter 262.102, 262.104, and 262.201. Again, sort of affecting those the list of reasons you cannot remove a child. So it actually forbids an emergency removal order or an emergency removal prior to a court order based solely on the medical opinion of a doctor who is under contract with DFPS and who has not personally examined the child. And when making determinations at the adversary hearing regarding immediate danger, the court has to consider the opinion of a medical professional who's been obtained by the child's parent. These changes in the law apply to suits affecting the child relationship, again, that are filed on or after September 1st of this year. So those are the cases that affect the circumstances pre-removal. There are additional bills that affect circumstances after a child has been removed. And the first bill that I want to talk about is Senate Bill 904 that's effective September 1st of this year. This bill amends Chapter 107.004 of the Family Code, and it requires that attorneys who are eligible to serve as an attorney ad litem on child welfare cases must complete a new trauma training requirement in order to maintain that eligibility. The attorney has to provide proof that they have completed a trauma program that includes training on trauma-informed care and on the effect of trauma on children who are in DFPS conservatorship. Now, this requirement is in addition to the existing training requirement for the 3 hours of legal education that have to be completed each year. However, this training can apply toward that 3-hour requirement if it is completed in that same year that the attorney needs to complete those 3 hours. The attorneys have to complete this requirement as soon as practicable after they're qualified for appointment, but it requires them specifically to complete this training no later than September 1st of 2022. The bill does not specify a specific length of time that this training must complete, but it does have specific requirements for what that training must include. I'm not going to go over those requirements here, but the bill lists those specific requirements that the training program has to meet in order to qualify for this provision. Moving on to House Bill 3774, which is also effective September 1st of this year. This also made changes to Chapter 107.004, and it made changes to the provision that required attorneys for children to file a written statement with the court regarding whether or not they had visited a child. Those requirements were triggered by whether or not the child attended court or whether or not the child caregiver attended court. That has been altered. So now there's no longer a written statement that needs to be filed with the court, but an attorney ad litem for a child has to report to the court at each hearing whether or not they met with the child or the child's caregiver as required by the statute, or if they did not meet with the child, that they are requesting a finding of good cause that meeting with that child was either not feasible or is not in the best interest of the child. Now, this duty importantly applies to suits filed under Chapter 264, in addition to suits under Chapter 262 and 263. So there's now kind of unity in all suits, whether they're court-ordered services or removal, regarding the duties of the attorney ad litem. Moving on to House Bill 1227, also effective September 1st of this year. This affected Family Code Section 154.001, and it requires a court that is providing over a SAPSR filed by DFPS, if that court orders child support payments or modifies existing child support payments and requires those payments to be made to DFPS, the court has to notify the Office of the Attorney General within 10 days. It's also important to note that this provision affects proceedings that are pending in the trial court or that are filed on or after September 1st. So this affects proceedings that have been filed prior to September 1st of this year. Moving on to House Bill 1350, this amended Family Code Section 107016, and it requires that a court order that appoints DFPS as the permanent managing conservator of a child has to continue the appointment of an attorney ad litem or the guardian ad litem or the attorney serving in the dual role of the child as long as the child is in DFPS conservatorship. The court may continue the appointment of both the attorney and the guardian ad litem, but is not required to. This is a little bit complicated, but the easiest way to think about it is at least one of the guardian ad litem, attorney ad litem, or the attorney in the dual role has to continue with that child once they transfer to PMC, as long as that child is in the conservatorship of the department. And again, importantly, this provision applies to proceedings that are pending in a trial court on or after September 1st of this year. Moving on to Senate Bill 1575, that is effective September 1st of this year. This is a bill that amends Section 263 as well as 264. And the intention of this bill is to ensure that children who are placed in qualified residential treatment centers receive the legal procedure that is required by the Federal Family First Act. The Federal Family First Act, one of the things that it did is that it specified that only certain placements will be eligible for federal reimbursement. And qualified residential treatment centers are one of those placements that are eligible for federal reimbursement. But in order to get that federal reimbursement, there was also a specific legal procedure that had to be accomplished for children in those placements in order to get that federal reimbursement. And so what this bill does is it codifies those federal requirements in the Texas Family Code for children who are placed in these qualified residential treatment centers, or QRTPs. Now, it's important to note that this only applies to children who are placed in QRTPs. And as of yet, I do not believe there are any facilities in Texas that are fully licensed as QRTPs. I know DFPS is working on a pilot program regarding QRTPs, but I don't think it is quite ready yet. So when a child is placed in a QRTP, within 60 days of that placement, the court has to consider the assessment of that child that's required under the Federal Family First Prevention Services Act regarding that child's placement. The court has to determine whether the child's needs can be met through placement in a foster home, and if they cannot be met, whether placement in a QRTP provides the most effective and appropriate level of care for that child in the least restrictive environment and is consistent with the long-term and short-term goals for the child as specified in their permanency plan. The court then has to approve or disapprove the placement, and any documentation for the review of that decision has to be included and made part of the child's permanency plan. As long as the child remains in that QRTP placement, DFPS has to continue to provide the court with information at every status review and at each permanency hearing regarding that ongoing assessment of the child's strengths and needs, and showing that their needs cannot be met through placement in a foster home. They also have to continue to show that placement in a QRTP provides the most effective and appropriate level of care for the child in the least restrictive environment, and also continue to show that that placement is consistent with the long-term and short-term goals of the child in their permanency plan. DFPS also has to provide information documenting the specific treatment need and the specific service that will be meeting that need for the child in placement. They have to document the length of time the child is expected to need that treatment or service, and the efforts that have been made by DFPS to prepare that child to be placed either home with their parent, in a foster home, with a relative, with another legal guardian, or with an adoptive parent. Review of a child's placement in a QRTP may be conducted through a remote proceeding, and placement of a child in a QRTP is considered a significant event that triggers the notice requirements to all parties under Section 264.018. So moving on to House Bill 2924, this bill amended Section 161001, and what it does is it prohibits courts from entering a finding of termination based on the M ground. The M ground is something I think most of us are familiar with, which allows termination based on a prior finding of D&E. So this prohibits courts from making a finding under that ground unless the petition is filed before the first anniversary of the date that DFPS was granted managing conservatorship in the case where the parent's rights were terminated under D&E. So essentially, if you want to go forward on ground M, you have 1 year to file against a parent whose rights were terminated on D&E. Now, importantly, it does not specify whether the triggering date is temporary managing conservatorship of the child or permanent managing conservatorship of the child. And that's quite unfortunate, since those are two very different instances in a case and would result in two very, very different deadlines for filing this provision. The bill also deletes prior termination of parental rights from the list of aggravated circumstances that can allow a court to proceed without a service plan under 262-2015. Now I'd like to cover some of the bills that affected CPS cases after a final order has been entered. And the first one that I want to cover is House Bill 2058. This bill is effective September 1st of this year and affects Family Code Section 263-503. And this is a very simple bill. All it does is add normalcy requirements that were required for permanency hearings before a final order to permanency hearings after a final order, so that those permanency hearing statutes are now in sync regarding the findings that must be made for normalcy for kids. Moving on to Senate Bill 1896, that was effective June 14th of this year. So it was effective when it was signed by the governor. This is a very, very big bill. This is probably the biggest bill that was filed this session. We're going to see a lot of it throughout this update. We tried to divide it up in ways that make the most sense because it affected a lot of different provisions. But this section of the bill amended Family Code Section 263-409, and it requires that before entering a final order that awards custody of a child in DFPS conservatorship to a relative, the court has to verify that that relative was offered the opportunity to become a licensed foster placement in order to qualify for permanent care assistance, and that the relative declined that offer, and if that relative was working with a child placing agency, that the agency has been notified of the relative decision to decline the ability to have PCA as an agreement. Moving on to House Bill 2926. This is effective September 1st of this year, and this is another bill that makes a very, very substantial change in the law because it allows a petition to reinstate a parent's rights once they have been terminated. So it amends Chapter 161 and Chapter 262, and it allows a petition to reinstate parental rights to be filed by DFPS. They can also be filed by an SSCC if they're in a region with community-based care. It can be filed by an attorney ad litem for a child or a parent's rights who are involuntarily terminated. I do want to pause and emphasize that that is a specific language. It can only be filed by a parent whose rights were involuntarily terminated. If the petitioner is the parent, they have to provide DFPS with 45 days notice of their intent to file. And the notice of that petition has to be served on the child, on the county attorney. I want to specify, it does specifically say county attorney, not the attorney representing DFPS. It has to be served on the child's attorney, on DFPS or the SSCC. It has to be served on the former parent if the parent is not the person filing this petition, and it has to be served on the tribe if the child is subject to ICWA. Continuing with House Bill 2926, this petition for reinstatement may only be filed 2 years after termination, and the child must not have been adopted or be in an agreed adoptive placement. The petition has to include the name of the petitioner, the name and address of the parent, the name and date of birth and residence of the child, contact information for any party that participated in the termination hearing or that has relevant information to the petition. And I just want to stop and emphasize that a lot of that information is important, but may be very, very challenging for a parent whose rights have been terminated and is no longer participating in the case to obtain some of that information. The petition also has to include a summary of the termination grounds. It has to include a summary of the facts and evidence that demonstrate the parent is now fit to be a parent, a statement regarding the child's consent if the child is 12 years or older, and a summary of the parent's prior request for reinstatement if the petition is being filed by someone other than the parent. Once that petition is filed, a hearing regarding that petition has to be held within 60 days. The petitioner has the burden of proof, and the burden of proof is preponderance of the evidence. And the required findings are that the court must find that the reinstatement of parental rights is in the best interest of the child. They have to find that the parent has remedied any conditions that were grounds for termination. And they also have to find that the parent is willing and capable of performing parental duties, that the 2 years have passed, that the child has not been adopted, and that the child consents if the child is older than 12. If the child is younger than 12, the court has to consider the child's wishes in making that determination, but is not bound by the child's wishes. The court, once this hearing is held, may grant the petition, it may deny the petition, or it may defer the petition for 6 months and render a temporary order awarding the parent possessory conservatorship. And that's sort of an interesting fact because their parent rights have not been reinstated, but they have been awarded this temporary possessory conservatorship. DFPS must continue to monitor the parent, and the court has to hold another hearing to revisit the reinstatement when the temporary order expires. If the petition is then denied, a new petition cannot be filed for 1 year after the date of the order denying that petition. There are some additional provisions in this law that are not related to reinstatement of parental rights that I want to make sure everyone is aware of. DFPS has to notify relatives that has identified of their right to file for a petition for conservatorship post-termination. So relatives have always had this ability. Now DFPS must notify them of their ability. It also adds language expanding the relatives that DFPS has to attempt to identify from the 3rd degree of consanguinity to the 4th degree of consanguinity. And just for your curiosity, 4th degree of consanguinity includes great-great-grandparents, great-great-grandchildren, and first cousins once removed who are children of first cousins. So that's now the pool of relatives that DFPS has to identify. Now, when making placements for decisions for a child, DFPS has to give preference in a hierarchical order from relatives to fictive kin, to foster homes, and then finally to general residential operations. So that's all of the changes that were made this session that were specific to CPS procedure. But there were also some procedures that were made to just sort of general SAPs or procedures that I think are relevant to the practice of child welfare law that I wanted to make sure everyone was aware of. And the first bill that I wanted to address was House Bill 868. This is effective September 1st, and it amended Family Code Section 105002, and it simply authorizes a jury verdict to make a ruling regarding the right to determine a child's primary residency when making either a joint managing conservator or sole managing conservator. So if that's an issue in your case, that can now go to the jury if that is one of the options when you're taking your case to trial. Also, I wanted to let everyone know about House Bill 32003 that's accepted September 1st of this year. It makes amendments to the standard possession order under 153.317, and it simply allows that for weekends that follow student holidays or teacher service days that fall on a Monday, possession now ends at 8 a.m. on a Tuesday. So if you're negotiating a final agreement in your case that references the standard possession order, it's important to know about these changes. Additionally, Senate Bill 268 that is effective September 1st made a lot of changes to how child support works. I'm not going to go into all of those changes, but there are a few that I wanted to highlight. For child support orders, courts cannot consider incarceration now as intentional unemployment or underemployment, but a child support obligor who is incarcerated in jail or prison for over 180 days, that now qualifies as a material change of circumstance that can justify seeking a modification of that order. Importantly, it also requires all parties under temporary or final orders to pay child support directly through the state disbursement unit, including employers who are court-ordered to withhold child support from an obligor's income. So there's no more payment directly to the caregiver. All payment, whether final or temporary, has to go through the state disbursement unit. Moving on to Senate Bill 1936, this is another modification to the standard possession order. So this bill states that the standard possession order for parents residing less than 50 miles apart has to alter the standard possession order to the alternative beginnings and endings of possession under section 153.317, unless a specific set of circumstances apply. And those circumstances are that the possessory conservator declines in writing or through an oral statement that they want those terms of possession, that the court is limiting, denying, or restricting the conservator's access to possession, that the possession times are not in the best interest of the child due to the distance between the parents' residences, or that the possessory conservator has not exercised their entitlement of possession of the child. So we're now going to talk a little bit about youth aging out of care and the bills that apply to that population, and Jamie is going to tell you about those bills.
Wow, let's take a collective breath. Thank you so much, Dylan. That was amazing. I appreciate you digesting an incredible amount of information in that short period of time. So as Dylan mentioned, I'll now turn to bills that focus on older youth and young adults in foster care. So the next 3 slides relate to House Bill 700. And this bill includes important provisions for older youth and young adults in care. If we could go to the next slide, please. The first part of the bill requires DFPS to address barriers to participation in preparation for adult living due to the youth's disability by making appropriate accommodations. Second, experiential life skills training must include lessons on identification documents. DFPS and the Texas Higher Education Coordinating Board must create a work group that includes members from rural and urban institutions of higher education. The goal of this work group is to provide college credit for completing standardized preparation for adult living curriculum. As a reminder, taking a college credit or dual credit course before turning 25 locks in the tuition and fee waiver for life, so this change could have a very significant impact on youth aging out of care. The work group must consider the feasibility of each recommendation, access to PAL program, and the average length of time the youth stays in each placement. The work group will release a report by November 1st of 2022. On the next slide, other key provisions for House Bill 700 include ensuring youth have access to an email account where they can receive encrypted documents and records, adding Medicaid or insurance plan cards to the list of identification documents youth must receive, and assisting youth with learning how to store important documents, as well as manage medications if the youth is age 17 or older. The final section of this bill includes important provisions aimed at addressing housing needs for youth aging out of care. For youth who will enter extended foster care, DFPS must complete paperwork for transitional living or supervised independent living 6 months before the youth's 18th birthday. The goal is to ensure that youth have housing on the day they enter extended foster care. Caseworkers must also review housing qualifications 90 days before the youth's 18th birthday. The bill requires DFPS to waive background checks if a youth continues living with the same caregiver. In these circumstances, youth can also share a room with another youth aged 16 or older, so long as the age difference is not more than 2 years. Foster parents must notify the caseworker 90 days before the youth's 18th birthday if the youth cannot stay there when they turn 18. Congregate care facilities must provide this notice 6 months in advance of an 18th birthday. However, if the youth is placed there less than 6 months before their 18th birthday, then the notice must be as soon as possible. Youth can also establish rental history by co-signing on their leases, and this bill makes that clear. And finally, the bill requires DFPS to develop a protocol to prevent youth from aging out of a residential treatment center placement. The next bill is House Bill 1062, and it adds youth in foster care to the list of individuals who can serve in the Texas State Guard. In order to serve, DFPS or another legal entity must consent in writing. Senate Bill 1059 is aimed at strengthening the process to determine Medicaid eligibility for youth formerly in foster care. Components for the streamlined process must include automatic enrollment, avoiding unnecessary interruption of benefits, and if recertification is required, providing a simple application and process. Changes made by the bill only apply to an initial determination or recertification of eligibility on or after 9/1/21, regardless of when the person applied. If there is a federal waiver or authorization needed, implementation may be delayed from this timeline. Senate Bill 1524 allows for tax refunds for qualified apprenticeship, defined as an apprenticeship that's certified as an industry-recognized program by an entity that meets Department of Labor criteria or is registered through the Department of Labor and qualified to receive funding from the Texas Workforce Commission. Under the bill, employers can receive a tax credit for up to 6 apprentices if at least half are youth currently or formerly transitioning to independent living. TWC will develop an application form for certification, and there must be merit-based criteria with preference to non-metropolitan areas and apprenticeships in emerging fields. The tax refund is subject to available funds, and there will be a report on the efficacy of the pilot by 9/1/2024. Senate Bill 1896 has been referenced in several sections of this presentation. Within youth and young adults, there are 2 relevant provisions. First, Section 4 requires DFPS and SSCCs to assess the feasibility of a volunteer mentor program for youth in congregate care facilities. This must be done in partnership with local government, faith-based, and community-based organizations. A report on the potential for a mentoring program will be completed by December 31st of 2022. Section 33 of the bill requires DFPS and HHSC to evaluate Public Law 116-260, the Consolidated Appropriations Act 2021, to maximize the use of federal funds to support transition planning and extended foster care services. DFPS and the Children's Commission released guidance and information about the provisions in the Consolidated Appropriations Act. These funds are targeted to youth aging out of care, reentry to care, and extended foster care, and they are very time sensitive. The DFPS PAL coordinators and the Foster Youth Justice Project team are invaluable resources for youth accessing these benefits as well. Senate Bill 2054 allows for the Texas Workforce Commission to pay for fees associated with obtaining a driver's license if the youth or young adult is younger than 26 and was in DFPS managing conservatorship on the day before their 18th birthday, or the youth is homeless. Funds for the identification fee exemption account can be used for this purpose. TWC will develop a rule for youth to apply for payment of these fees in the future. I will now transition to bills that are relevant to youth in the child welfare and juvenile justice systems. There were many bills related to juvenile law that passed during the legislative session, but our scope today will be more narrow. House Bill 80 states that in case of conviction in a criminal action before a justice of the peace or municipal court judge, the judge or justice cannot require a youth in DFPS conservatorship or extended foster care to pay fines or fees. Instead of payment, community service may be required. Importantly, these changes only apply to sentencing hearings that commence before, on, or after 9/1/21. House Bill 1401 builds on existing automatic sealing and sealing by application procedures that became law several sessions ago. This bill allows for applications to seal records by any reasonable means, including secure electronic filings. It also allows for the sealing order to be sent out electronically. House Bill 1664 allows for reinstatement of eligibility for medical assistance if a child is hospitalized or becomes inpatient while placed at a juvenile facility. HHSC will establish rules to outline the procedure for this process. Implementation may be delayed if an MOU is required. With the exception of traffic offenses, this bill, House Bill 2669, makes records related to fine-only misdemeanors committed by a child, as defined by Section 45.058, confidential and unable to be disclosed to the public. Files and records, including law enforcement and electronic information, are only open for inspection by judges and court staff, criminal justice agencies, the Department of Public Safety, an attorney for a child, the child, or the child's parent, guardian, or conservator. House Bill 3165 creates an affirmative defense to truancy that the child's absence was due to abuse at home. The affirmative defense is not available if, after subtracting the absences due to abuse, there are still enough absences to constitute truant conduct. The burden is on the child to prove by a preponderance of the evidence that the absence was due to abuse. Courts have the ability to consider other factors that could excuse the absence as well. Although the law is already in effect, it begins with school year 2021-2022. The next bill, House Bill 3774, you may recognize as an omnibus bill with many provisions related to Texas courts. Section 4.02 of the bill kicks off the dual status provisions. In 2018, the Texas Judicial Council charged the Children's Commission with establishing the dual status task force to develop recommendations for an improved response to youth who experience both the child welfare and juvenile justice systems. From the outset, there was agreement that defining dual status is a threshold need so that everyone can speak the same language. The definition in House Bill 3774 reflects the recommendations in the task force in large part. It defines a dual status child as simultaneously involved in both systems. For juvenile justice involvement, that's defined as having been referred to the juvenile justice system. That's simple. For CPS, the child's either in TMC or PMC, is the subject child of an FBSS case, is an alleged victim with an open investigation, or a confirmed victim in an investigation that resulted in a reason to believe finding. The bill also includes the term dual status child in provisions related to the Child Protection Court's jurisdiction over these cases. In the final slide in this section, Senate Bill 2049 includes two definitions, dual system and dual status. These definitions are consistent with the previous bill. The difference between the two terms, however, is that dual system is non-concurrent involvement, meaning non-simultaneous involvement. Juvenile justice system is historical, child welfare is current, or vice versa. Dual status is that concurrent simultaneous involvement in both systems at the same time. This bill resulted from collaboration with the Dual Status Task Force and the Legal Representation and Advocacy Work Group. Texas CASA was integral in this process to carve out a framework for guardian ad litem in dual status cases. 2049 allows the guardian ad litem on a child welfare case to also serve in that capacity on the juvenile case. For non-attorney guardians ad litem that serve on both cases, they cannot investigate charges pending in juvenile court or offer testimony at the guilt-innocence phase. The goal here is to avoid the GAL becoming a fact witness in a juvenile case. The bill goes on to add language that provides opportunities for the GAL to offer input at multiple stages of the juvenile case. Finally, the GAL on the juvenile case can serve in the CPS case if they're otherwise qualified. I will now turn it over to Amy to discuss human trafficking in education.
Hello, thank you for joining us. I'm going to tell you about a few laws that enhance anti-human trafficking efforts and are going to give more support to survivors. A little later, you're actually going to hear from Dylan about the House Bill 1896, and this instructs DFPS to expand placement capacity to include providing care for children and youth who are at risk for human trafficking. I will now turn your attention to House Bill 1540. As many of you know, children in foster care are at a higher risk of being exploited. Traffickers are drawn to residential treatment centers to seek out their victims. And previously, human trafficking a minor was actually only a second-degree felony. But House Bill 1540 actually raises sex trafficking to a first-degree felony if that person was recruited from an RTC. So it's definitely going to give some additional protections and harsher punishment for children in RTC. Additionally, this bill includes a change or an amendment of the definition in the Family Code. So the definition of abuse under Family Code 261.001.1G includes that now solicitation of prostitution is part of the definition of child abuse under the Penal Code. The next House bill that impacts human trafficking is 263.3. Now, this law creates a trafficked persons program account. And so it is going to support survivors of human trafficking, and the account is going to be funded voluntarily by driver's license contributions, specialty license plates, and other donations. And DFPS will be able to kind of manage these housing and other treatment facilities. We are now going to switch over to education. And next slide. House Bill 159 is going to amend the education code. So the focus is going to be on training teachers of students with disabilities. It actually defines who a student with a disability is. It adds training requirements for educators related to students with disability, along with adding the ability for principals or superintendents to create an inclusive environment and a foster parent involvement as one of their certification qualifications. So principals and superintendents have to meet certain qualifications. And so this law is actually going to allow and kind of encourage them to create foster parent involvement in order to meet those qualifications. Next slide. House Bill 725, this is a really great one. It is actually going to also amend the education code, and that is 29.153B as in boy. So this law is going to permit a child who is at least 3 years old who has ever been in any foster care in Texas or in any other state or territory to enroll in kindergarten and pre-kindergarten. So this is actually a change because it was previously limited to only children in Texas foster care. But as we all know, so many children, through ICPCs, family placement may be involved in another child welfare system in another state. And so this is actually going to let them enroll in pre-kindergarten here in Texas. The next House bill is 785, and this law is going to impact special education. So before a child is enrolled in a special education program, school districts typically establish a committee to develop an individual education program. It's also known as an IEP. And if this committee, it gets to determine what special education services are needed and if a behavior improvement plan is needed. So there's actually a new section to the code that is created, and it's 29.005H. And this now requires an annual review of that behavior intervention plan, or BIP. And it's going to account for changes in the student's circumstances that might be impacting their behavior. So some change in circumstances are going to include change of placement, increased disciplinary actions that are taken for similar behavior, a pattern of unexcused absences or departures from school, along with the child's safety and other safety of the others. So for our children in foster care, we hope that this is really going to help schools and caregivers connect a child's behavior with what's going on, some behind the scene changes. So this is going to require an annual review of that behavior plan. So the law also requires written notice to parents for each use of a restraint or timeout on a student, and it's going to require lots of details about the restraint, why it happened, what were the circumstances surrounding it. So it's a lot more accountability of what's going on to our kids in schools. We are now going to move to Senate Bill 89, and this is going to be known as the COVID-19 Special Education Recovery Act. So this adds a whole new section to the Education Code, and it is effective now. But because it is specifically COVID-19, it has an expiration date. So this Recovery Act expires September 1 of 2023. So the new section to the Education Code is 29.0052. And this is going to require school districts to prepare supplements for each child who has an IEP, like I previously mentioned, that was enrolled in the special education program, either in the 2019-2020 school year or 2020-2021. So the supplement must provide information about the child's full individual and initial evaluation, the programs that they were supposed to complete, if it was not completed, if it was interrupted, what were the delays, the suspensions, discontinued services, and it also must identify are compensatory education services appropriate for this child. Now, there is a deadline that schools must have this supplement done by May 1st of 2022. So if the child's IEP for the prior school year already has this information to account for the COVID-19 setback, a supplement isn't necessary. But because this law is one that is very specific, you'll definitely want to go back and revisit if you have a student that you think might benefit. So again, that's Education Code 29.0052, and it does have very strict deadlines. So make a note, star that one. The next Senate bill is Senate Bill 279. And so this adds some provisions for mental health. It adds a suicide prevention information on a student's ID card, and it is part of the Education Code. As we know, mental health and suicide prevention is of growing concern for our students. And so this new bill actually requires public school student identification cards to have the National Suicide Prevention Lifeline and Crisis Text Line right there on the card for students who are in 6th grade or higher. So the card should also have contact information for the campus police, security, mental health line, local suicide prevention hotline. And so really getting the information into kids' hands about suicide prevention help, mental health help. The next Senate bill is 1760, and it's another great new law that's going to help students in special education who may have fallen behind in school. So this also adds an entire new subchapter to the Education Code, Chapter 29. It's A1. And so in Chapter 29, it's 29.041 through 29.050. And this is called the Supplemental Special Education Services. And so what this bill is going to do is it directs TEA to establish and administer a supplemental special education service and materials for students who are eligible for this compensatory education. It's going to have a grant and application process, and students who qualify, they will be assigned an account in order to purchase these additional services. The grants can be up to $1,500 per child. And they can include things like occupational therapy, physical therapy, speech therapy, private tutoring, and other programs that are going to need to be pre-approved. So this also has a pretty strict time limit, and the law itself will expire September 1st, 2024. But I think that $1,500 is going to come, a long way to really help our students. Next, we have Senate Bill 1896, and I did mention earlier that this bill does have some anti-human trafficking and survivor supports, but it also includes provisions related to education for students in RTCs and emergency shelters. As we kind of discussed, children in RTCs are at a more vulnerable place. And so this actually requires Dfps to develop a strategic plan for improving educational services to children who are placed in RTCs, emergency shelters. It also is going to require that TEA report on the educational outcomes for children in these placements. And for Dfps and TEA to come together and to evaluate the educational outcomes for these kids in these placements. As you know, kids in these placements often change multiple times. There's break in continuity of their education. And so we're hopeful that this new law will help ensure that the children in RTCs and emergency shelters are getting the right kind of education that they need. So this concludes the updates regarding human trafficking and education, and I will turn things back over to Dylan.
Thank you, Amy. I'm now going to talk about some bills that affected issues regarding domestic violence and protective orders. And I'm going to start with House Bill 39 that's effective September 1st of this year. This is, again, a very large bill that makes a lot of changes to Family Code Section 85 and 86, as well as the Code of Criminal Procedure and the Penal Code. And what it does is it allows an agreed protective order to be both civilly and criminally enforced, regardless of whether the court makes findings that would be sufficient for a protective order. So if the parties agree to the protective order, then those findings are not necessarily required as long as the parties are in agreement. It also allows any adult, not just a parent, to file for a protective order on behalf of a child victim for certain offenses. It also allows the attorney for the state to file a protective order regarding victims once an offender has been convicted, but it does restrict the attorney for the state from filing if the victim objects to the protective order unless that victim is a child. It also allows a protective order to be issued for life. And when I say life, it is both the life of the victim and the offender against certain registered sex offenders for certain victims of sexual offenses. It also restricts a parent from rescinding a protective order if they were the offender and the subject of that protective order. House Bill 39 also creates sort of a buffer period for protective orders that are applied to persons who were incarcerated when that protective order was created, so that the protective order continues to apply sort of a minimum period of protection once that person is released. So if a person is subject to a protective order and released from incarceration after the date the protective order would expire, or the order would expire within 1 year of that person's release, the order is automatically extended to expire on the first anniversary of the date the person's released from incarceration, if that person was serving 5 years or more, and it expires the second anniversary of that person's release if that person's sentence was 5 years or less. Now, this bill has a very complicated effective date. It depends on when the protective order was approved, on when the respondent received service, on when the application was filed, and when the judgment of conviction was entered. So this is a very, very complicated effective date that I do not have the time to go into here. So if this is a provision that is relevant to you, I highly recommend looking up this bill specifically to find out the effective date and if that applies to a case that you're working on. Moving on to Senate Bill 798, that's effective September 1st of this year. Again, this is a fairly simple bill that amends the Health and Safety Code and the Transportation Code, and it simply allows fees to be waived for either victims of dating or family violence or children of victims of dating or family violence to obtain a copy of their birth certificate, a personal identification certificate, or a driver's license. So now those people can get those needed identification documents without having to pay a fee. Moving on to House Bill 1172, that is also effective September 1st of this year. This amends the Code of Criminal Procedure and simply requires a peace officer to offer a victim of sexual assault the opportunity to have a trained sexual assault advocate or crime liaison or a counselor present when they're being interviewed by law enforcement. So I'm now going to move on to some bills that affected drug and alcohol recovery, since that's an issue that often overlaps in a lot of CPS cases. And I'm going to start with House Bill 707 that's effective September 1st of this year. There's no code citation in this bill, but what it does is it directs the Health and Human Services Commission to conduct a study to evaluate what are the current opportunities, challenges, and needs to expand recovery and housing in the state. The study has to include interviews with stakeholders, it has to include interviews with experts in recovery housing, and it has to represent both rural and urban areas of Texas. The Health and Human Services Commission has to prepare and submit a report regarding this issue to the legislature no later than December 1st of 2022. And since this is a temporary provision, it expires September 1st of 2023. Moving on to House Bill 454, that's also effective September 1st of this year. This amends Government Code Section 130004, and it authorizes commissioners' courts to establish a juvenile family drug court program that's focused on the rehabilitation of an individual who is suspected of substance abuse by Dfps and who resides with a child who is the subject of a juvenile case. Now, I want to be clear, it doesn't actually require Dfps involvement, either through a legal proceeding or other proceeding. And interestingly, the person who is the subject of the rehabilitation is not the person who is actually the subject of the proceeding. The subject of the proceeding is the youth who is in the juvenile case. So it's a little bit of a new and interesting procedure. Counties that are interested in creating such courts, they have to explore court improvement project money, as well as other state and federal matching funds that may be available to finance these sorts of courts. Moving on to bills that affected sort of foster care licensing, as well as kinship ability to take care of children in foster care and support other children. So the first bill I want to talk about is House Bill 1387. This bill is effective September 1st of this year. It amended the Human Resources Code, Section 42042, and it allows foster parents to store firearms and ammunition in the same locked location without a trigger locking device on the firearm. The previous law stated that those firearms and ammunition had to be stored in separate lock locations. Now they can be stored in the same location. The bill previously said that if you had a trigger locking device, you could store them together. Now a trigger locking device is not required. So those are changes to the ability of licensed parents to own and keep a firearm in their home. House Bill 1927 was also a very large bill that dealt with firearms. And essentially the major theme of the bill was that it allowed people to carry handguns without necessarily requiring a permit, but as long as that person was not prohibited from carrying a gun by law. So that provision applied to certain sections that applied to foster parents. So this bill amended the Human Resources Code, Section 42042, that prohibits DFPS from prohibiting a foster parent from transporting a child in a vehicle where a handgun is present if that handgun is in the possession and control of the foster parent, and the foster parent is not otherwise prohibited by law from carrying that handgun. Moving on to Senate Bill 1896, again, the bill that affected many, many different parts of the child welfare system. One of the things that also did was affect suicide prevention requirements at certain placements. So this bill amended the Human Resources Code, section 420433, requiring the commissioner to adopt a model suicide prevention, intervention, and postvention policy for use in residential treatment care facilities. Each RTC then must adopt either the model policy or another policy that's been approved by the commissioner. HHSC must then provide to the residential care facility any technical assistance that is necessary to adopt or implement that suicide prevention, intervention, and postvention policy. Continuing with Senate Bill 1896, it also amended Human Resources Code 420538 and 420583. And this allows the Health and Human Services Commission to allow child placing agencies to issue a provisional license to kinship providers who meet basic safety requirements provided by a commission rule. That kinship provider who is issued this provisional license under this section, they still have to complete all the licensing requirements within the time provided at the rule, but they can sort of get this provisional license without having to jump through all of the requirements right from the very beginning. The bill also requires DFPS to use data analytics that are collected regarding residential treatment care providers, and that includes general residential operations providing treatment services to young adults who have emotional disorders, and they have to develop an early warning system to identify providers who are at risk and in most need of technical support to try to promote corrective actions and minimize standard violations. This early warning system has to distinguish between different levels of risk using a multi-point severity scale and make information regarding that severity scale available to the public through the DFPS website. Staying with Senate Bill 1896, it also amended Human Resources Code section 42256 and 42260 regarding general residential operations that contract with DFPS. Those that contract to provide residential care for children in foster care have to submit information on their treatment model to DFPS, and that operation has to annually assess the effectiveness of that treatment model. The treatment model has to include the manner in which those treatment goals will be identified for each individual child. They have to identify the method of operation that will be used to measure the effectiveness of those treatment towards those treatment goals. They have to measure the actions that the operation will take if the treatment goals are not met. And they have to identify the method of operation that will be used to monitor and evaluate the effectiveness of those treatment models. So it's a lot of due process in making sure that those RTC treatment models are public and reviewed and improved over time. Staying with Senate Bill 1896, a general residential operation that considers accepting a child's placement within their facility, they have to evaluate whether the child meets the operation's admission criteria. They have to evaluate whether the child would benefit from their treatment model, and they have to evaluate whether they have the staff and resources to meet that child's needs, considering all of the other children that are already placed at that facility and those children's needs. If DFPS or an SSCC contracts with a general residential operation that's providing services to place children with that operation before that operation is licensed, that contract has to limit the number of children that may be placed there each month, and it has to limit the number of children who can be placed there who have a specialized, intense, or intense plus level of service. The general residential operation has to also develop a transition plan for each child that has been placed at that facility for longer than 6 months. So again, emphasizing that this is a temporary place for children, not a place for children to spend a great deal of time. Moving on with, continuing with Senate Bill 1896, some of its other provisions, it modifies sections of the Government Code 2155089 that exempts child-specific contracts that are entered to by DFPS for a child without placement from vendor review requirements. So it's trying to remove some of the bureaucratic red tape in finding placements for children who are without placement currently, and we know that's a crisis that we're all currently experiencing. There's no specific code citation for this next provision, but the bill does require the Health and Human Services Commission to adopt some minimum standards related to continuum of care operations, as well as cottage home operations and specialized care homes, and they have to complete this by January 1st of 2024. So I'm now going to cover some of the bills that affected the issue of placement capacity, and again, this is an issue that I know is on a lot of people's minds right now due to a lot of the capacity crisis that certain jurisdictions are experiencing. So I want to start with Senate Bill 263 that's effective September 1st. This amended Human Resources Code section 310041 and 31024. And It's not specific to relative caretakers who are taking care of children who are in CPS custody, but it applies to actually all relative caretakers of dependent children. It allows them to receive supplemental financial assistance and become protective payees for financial assistance payments for those children. These qualifying relatives can be a grandparent, they can be an aunt, an uncle, a sister, or a brother, as long as they meet the definition in section 31002, but they must be 25 years or older and they must be living with the child. Returning to Senate Bill 1896, it amended Family Code section 264-107 that allows employees of single source continuing contractors, in addition to employees at Dfps, they may now provide emergency temporary care for children who are without placement. But the bill does amend the Family Code section 264-1071 that restricts Dfps from allowing children who are without placement to stay overnight at Dfps offices. So another appropriate placement other than a Dfps office has to be found for that child to stay overnight. Continuing with Senate Bill 1896, it also amends Family Code section 264-1073 to try to expand the utilization of treatment foster care. And treatment foster care is foster care that's receives more training and more support, and to try to establish foster homes that can care for more high acuity kids who have more intense needs. And what this section does is it expands the ability to provide this kind of care by allowing single parents to now qualify as treatment foster care providers. Previously, only two-parent households could qualify. It expands the eligibility of children who can be placed in treatment foster care down to 10 years old or older, so it reduces the age and expands the pool of children who can receive this service. It also requires DFPS and SSCs to plan for a subsequent placement no later than 30 days after placement in treatment foster care to sort of ease the transition from treatment foster care to an even less restrictive setting. It also extends the length of time children can be placed in treatment foster care so that they can provide the appropriate level of therapy so that child could hopefully be effectively transitioned to a less restrictive placement. Continuing with Senate Bill 1896, it also amended Family Code section 264-1261. And this requires the Health and Human Services Commission to collaborate with both DFPS and single source continuing contractors to develop a plan to increase placement capacity in each catchment area of the state. Again, with the goal of eliminating the need to place children outside their community. So really focusing on making sure that children are not moved all around the state to find a placement that meets their needs. This plan must evaluate the best methods for meeting capacity shortages, including contracting for additional capacity at residential treatment centers, at inpatient and outpatient mental health facilities that are for crisis intervention for children with severe behavioral or mental health needs. And it also has to make recommendations for DFPS regarding contracting for additional capacity. Now, importantly, inpatient or outpatient facilities must still discharge a child within 72 hours once it is determined it is not medically necessary to place the child there. So those facilities can be used for capacity, but they can't simply be used to house children who do not medically need to be there. The plan must also have contingencies if a facility is placed on probation, and DFPS and single source continuing contractors must contract with facilities for reserve capacity. So in other words, they have to have capacity on standby that they aren't currently using, but that they may use if there's an increase in that capacity need. Importantly, the bill also repeals section 264-1261, which provided some prior definitions of community-based care. And Jamie's going to talk a little bit later on about some of those new definitions of community-based care in that section of the presentation. Continuing with Senate Bill 1896, it also amended sections of the Government Code 533-00521 that requires the Health and Human Services Commission to annually evaluate the use of benefits under the Medicaid program and the Star Health program that are offered to children in foster care, and provide some recommendations to DFPS and each single source continuing contractor to coordinate the provision of health care and the use of those benefits for children in foster care. 1896 also requires HHSC to identify some options to obtain federal run funds to pay for safe, home-like or community-based residential care settings for children who are in the conservatorship of DFPS. And those children that the bill specifies that DFPS has to identify these services for are children who are diagnosed as having serious behavioral or mental health conditions that requires intensive treatment, children who are victims of serious abuse or serious neglect, for whom a traditional substitute care or contracted placement is simply not available or would further denigrate the child's behavioral or mental health condition, or children for whom DFPS determines that a safe, home-like or community-based residential placement could stabilize their behavior or their mental health condition in order to return them to a more traditional substitute care arrangement. Senate Bill 1896 also instructs DFPS to develop, to the greatest extent possible, capacity for placement that is eligible for reimbursement under the federal Family First Prevention Services Act. And that's an act that we've mentioned a lot. And again, that bill specifies that only certain facilities will be eligible for federal reimbursement. And some of those facilities are listed here in this bill. And they include facilities that specialize in providing prenatal, postpartum, and parenting support for youth, facilities that provide high quality residential care and supportive services to children and youth who are at risk for human trafficking, as Amy mentioned earlier in her human trafficking portion. It also includes development of facilities for providing supervised independent living for young adults, for those offering residential family-based substance abuse treatment, and those serving as qualified residential treatment programs, or QRTPs, that we talked about previously in this presentation. Continuing with Senate Bill 1896, there is no code citation for this provision, but it does require DFPS to study how to extend permanent care assistance agreements benefits to individuals who are not relatives of the foster child or did not have a long-standing and significant relationship with the foster child prior to that child entering foster care. The study has to assess the potential impact and on favorable permanency outcomes for children who might otherwise either remain in foster care for very long periods of time or receive managing conservatorship to their caregiver without any benefits that are assigned to that caregiver. DFPS has to study this issue and issue a report to the legislature based on the results of this study and has to make recommendations for further action by December 31st of 2022. And because this is a temporary provision, it expires September 1st of 2023. And we're now going to move on to bills that affect DFPS operations, and Jamie is going to talk to us about those bills.
Thanks, Dylan. Well, as you all know, DFPS is a key partner for the Children's Commission, and in the next two sections of our presentation, I'll outline some of the larger administrative changes to the department as a result of the 87th legislative session. I just want to mention that DFPS is likely to provide its own legislative and implementation updates, and these changes are included in our presentation because we really didn't feel that a legislative update would be complete without this information. As a reminder to those of you entering questions in the Q&A feature, we very much appreciate it. Please keep them coming. I will try to wrap up as quickly as I can so we have time for Q&A, but please include that bill number if it's applicable. That'll help us answer questions. Thank you. Okay, next slide, please. So the first bill that I'm going to discuss in operations is House Bill 2374, and it creates a new section in the Human Resources Code. It defines an efficiency audit as an investigation of the operations of DFPS to examine fiscal management, efficiency, outcomes for children and families served by DFPS, and utilization of resources. Efficiency audits are required during state fiscal year 2022 and every 4 years thereafter. The LBB, the Legislative Budget Board, will set the scope of the efficiency audit and determine areas for investigation of the audit, including review of DFPS's use of resources to determine whether they are being used efficiently and effectively to achieve safety, prevention, minimizing time and care, placing children with relatives or kin, ensuring sufficient placement capacity, decreasing the number of youth aging out of care, and increasing reunification. The audit will identify opportunities for reallocation of resources and how to consolidate efforts or avoid duplication. The audit is due on November 1st of the years it's required. Up next is Senate Bill 452, which adds the requirement for evidence-based programs or practices to be associated with a national or state organization, an institution of higher education, or a national or state public health institute. It also lays out the requirements for evidence-informed programs or practices that combine well-researched interventions with clinical experience and ethics and client preferences and culture. It also has to have an active impact evaluation or demonstrate a plan to implement one. It substantially complies with a program or practice manual or design and employs well-trained staff with opportunities for professional development. The bill also requires a report on December 1st of odd-numbered years on state-funded prevention and early intervention programs and practices. Senate Bill 642 is our next bill that defines a relinquishment avoidance program as one that provides mental health services to a child with severe emotional disturbance without the child entering the conservatorship of DFPS. Pursuant to the bill, HHSC cannot require DFPS to investigate abuse or neglect before allowing the child to participate in a relinquishment avoidance program unless there is an allegation of abuse or neglect. An LMHA may refer a child directly to the relinquishment avoidance program without contacting DFPS first. DFPS and HHSC must develop joint guidance that describes how to access services and the child and family's rights when the parent or legal guardian either relinquishes or participates in the relinquishment avoidance program. The information will be available to caseworkers working with families and to families with children who have a severe emotional disturbance. The agencies will also develop protocols to determine eligibility, how to apply to the relinquishment avoidance program, case management, funding and resources, as well as roles and responsibilities. Senate Bill 910 lays out the components of a study aimed at developing a comprehensive list of options for implementing family preservation services in existing catchment areas. Under this bill, family preservation services is defined as a time-limited, family-focused service, including a service contemplated under FFPSA, the Family First Prevention Services Act, or a candidate for foster care or pregnant or parenting youth. Enhanced in-home supports, including non-recurring financial support and services to support self-sufficiency and prevent the need for future system involvement. The options must include contracts with SSCCs or procurement through a competitive bidding process. The options must also examine how DFPS provides FBSS services, family-based safety services, and how these functions would work in a contract model, reviewing lessons learned from the past 10 years and considering issues such as financial modeling, how to increase the evidence base for family preservation programs, performance measures, and maximizing existing funding streams. The study is due on October 1st, 2022. Dylan already laid out the provisions related to placement in a QRTP and court review under Senate Bill 1575. Section 3 of that bill required DFPS and the Children's Commission, that's us, to establish a work group to study placement of children in residential treatment programs and qualified residential treatment programs. The work group must address topics and changes to current practices, including judicial review, financial implications for additional court time, duration of placements and best practices for transition planning, proposed statutory changes, and model court orders as appropriate. The report is due October 1st, 2022. Please contact me, Jamie Bernstein, directly if you have any questions about this study or the work group. And as I mentioned, it will be broader than QRTPs and really apply to all residential treatment center placements. The Children's Commission is also slated to partner with DFPS on evaluating the department's use of the Forensic Assessment Center network and to develop recommendations to evaluate agreements between DFPS and the network, as well as best practices for using assessments provided by the network in connection with abuse or neglect investigations. This report will be due to the Legislature on September 1st, 2022. Section 19 of Senate Bill 1896, which you've heard a lot about already today, requires HHSC and DFPS to make their searchable databases accessible to one another. Section 31 of the bill also required DFPS to transition FBSS services that pass muster under Family First, develop a plan to transition services, and develop community referrals to existing prevention and early intervention programs by January 1st of 2025. The final section of this presentation is community-based care, and we'll do that before opening it up for question and answers. I'll focus here on changes made during the 87th legislative session. Section 6 of Senate Bill 1896 defines community-based care, as Dylan mentioned before, as the provision of child welfare services by a community-based nonprofit or local governmental entity that fulfills state and federal child welfare goals. It includes direct case management to prevent entry into foster care, reunify and preserve families, ensure the 3 prongs of safety, permanency, and well-being are met, and reduce recidivism. Section 7 of the bill states that if the SSCC is a nonprofit, The majority of board members must reside in the state of Texas. The bill also requires input from local stakeholders in preparing to roll out in a catchment area or in selecting an SSCC to provide services in the catchment area. The section of the bill allows SSCCs to apply for a waiver of any statutory or regulatory requirements in regions that have not been identified for community-based care and in regions where the SSCC already operates. The goal, and I believe we're on the next slide, the goal is to further innovation and flexibility in providing child welfare services. This section of 1896 imposes a duty on DFPS to identify catchment areas for community-based care and retain an independent entity to evaluate implementation and SSCC performance. The bill also includes a requirement for DFPS to accept unsolicited proposals from Texas-based entities for regions that have not yet rolled out community-based care. The entity must meet the criteria to become a single source continuum contractor, or SSCC, and demonstrate connections to the catchment area. So they want those local connections, very important. The bill also gives DFPS flexibility to modify catchment areas to accommodate appropriate unsolicited proposal. So this is really aimed at giving DFPS the flexibility to roll out community-based care. Under Senate Bill 1896, a single source continuum contractor can diverge from DFPS procedures so long as it fulfills its statutory duties. Again, that will give the SSCCs more flexibility to assume their duties. The DFPS Data Access and Standards Governance Council must develop protocols for the interoperable transfer of data, and the bill outlines council members and requires quarterly meetings. Section 12 lays out the composition and charge of the Joint Legislative Committee on Community-Based Care Transition. The committee includes 3 members of the House and 3 members of the Senate, appointed by the Speaker and the Lieutenant Governor respectively, who also name the chairs. The committee will meet as requested by the joint chairs and may consider public testimony. The charge of the committee is to report on and monitor implementation of community-based care, including funding, performance and outcomes, barriers in statute or regulation, and other implementation challenges. The committee will produce a written report by January 1st of each odd-numbered year. Section 12 of 1896 also creates the Office of Community-Based Care Transition. It is an independent office, but it is administratively attached to DFPS. Duties include assessing catchment areas where CBC may be implemented, developing a plan to implement community-based care in each catchment area, including the order for rollout, evaluating community-based care providers, contracting with providers, measuring contract performance of providers, and providing contract oversight. On the next slide, the Office of Community-Based Care Transition will also be responsible for reporting outcomes, identifying staff and other resources to be transferred to providers, creating a risk-sharing funding model, and requiring annual review of funding, rates, and regional service usage. In short, this office will be responsible for overseeing all aspects of the transition from the legacy system to community-based care. The director of the Office of Community-Based Care Transition is appointed by the governor and reports directly to the governor. Tricia Thomas was already named to this position and recently joined a public-private partnership meeting, and we very much look forward to working with her. The Office of Community-Based Care Transition must report at least quarterly on its progress, and the office will only operate until community-based care is implemented statewide. Here's our final slide, which is our question slide. And we know that this presentation has generated a lot of questions that we won't be able to get to today. I will open it up for questions here in a second, but I just want to state, whether you joined us live or you're watching at a later date or watching via YouTube, please contact us at children@txcourts.gov with questions. We will try to be as responsive as we can. I have heard from many of you in the question and answers that you would like to have reviewed the PowerPoint in advance. That is something we will definitely consider moving forward. We tried to make the slides as comprehensive as possible. And as I mentioned earlier, we will have a written legislative update that we will distribute as well. It will be organized by bill number and by code section. So hopefully you'll have everything you need in written form. And we will follow up from an announcement that we will provide, as well as putting it on the Children's Commission website for free. As I mentioned at the beginning of the presentation, CLE is still pending, and that if we are approved, we will distribute that information at a later date as well. So now it's time for me to stop talking and turn it back to Dylan to see what questions we've received.
Thank you, Jamie. We have quite a few questions. I'm not sure we'll be able to get to all of them, but I will try to answer as many questions as I can. One of the first questions that we received was related to House Bill 567, and it stated that while we emphasize that the change in the law regarding the rules regarding pleading requirements does not change the law, the question was, does that emphasize the sanctions contempt portion of Rule 13? That's a bit of a tricky question. I don't think it emphasizes those specifically. I think it emphasizes the totality. So I don't think it's intended to emphasize that sanctions particularly are something that needs to be considered. It just wants to emphasize that those rules apply to CPS cases and there's no CPS case exemption for those rules. I also think it's worth noting those rules regarding the basis that you need to have to include something in a pleading is fairly small. It's simply there must be some evidence or some reasonable belief that evidence will be discovered regarding those pleadings. So you don't have to be able to prove everything initially in that pleading. You just simply can't have a pleading that has no basis in fact or no reasonable basis that facts will be discovered regarding that pleading. So I think it's important to emphasize that while those provisions are in there, the flexibility on what is included in a pleading is still pretty substantial. Another question that we were asked was again regarding House Bill 567, and I believe this was a question regarding the procedure for making placement decisions for a non-offending parent. And I'm going to kind of break this question up into two questions. It says, for example, would a 15-year-old child who's been the victim of sexual abuse be placed with a father who was not present to parent that child? And what I will say is I think the bill does intend that a child be placed with a parent not by a best interest standard. So in that circumstance where a child may not have a relationship with that parent, as long as that parent is not a danger to that child, I think the bill's language would indicate that that child probably should be placed with that parent, even though there's not a pre-existing relationship. The second question that was sort of a follow-up is, what if that parent is a sex offender, but not towards the child that is the subject of this case? I think that provision would probably be covered by that second section of the bill that says the court can not place a child with that parent if placement with that child constitutes a continuing danger to that child. And I think certainly a court could find that if that parent had abused other children, that a child who had not been abused was still at risk of continuing danger if they were living with that child. So I hope that answers that question. We had a lot of questions regarding 567, so I'll try to get to as many of those as I can. One question asks, do we see any consequences for failure to participate in the court-ordered services or motion to participate section that's been built out by 264-203? And I think there's not specific consequences that are listed in that bill, but I think the consequences are sort of fairly natural. If that service has failed, if they are not participating in services, those services are designed to alleviate danger. So if services that are designed to alleviate danger are not being complied with, then the argument would be that that danger has increased and possibly removal is warranted at that point. Let's see, another question we had was regarding House Bill 135, and this was the bill that required Dfps investigators to communicate to a parent about their right to record that interview. And it asked, if the parent refuses to sign that document, does that prevent the caseworker from communicating with the alleged perpetrator? And I think, I'll have to go back and look at that bill, but I think the answer is no. A parent can always, I think, refuse to communicate. They always have their rights. But that bill simply had to do with the right to record the investigation. So I think if the parent, as long as they consent to the interview, if they refuse to sign that document, I don't believe that prevents the caseworker from continuing to interview unless the parent specifically refuses to be interviewed. Let's see. Regarding the authorization of temporary orders under Section 105, this is again, I think, a question that's directed towards the court-ordered services provision of Senate Bill 567. It asks, does that provision allow the court to grant temporary conservatorship to a non-parent in lieu of a court-ordered safety plan? That is a really good question. I do not think that is specifically contemplated by this bill. So that's not sort of included in the standard pleadings that are contemplated by this court-ordered services statute. I don't see anything that specifically prohibits that, but I don't think it's what the statute envisioned as an option under 105.001. Let me look at some of the other questions that are coming in. This is a good question that's come in regarding the bill that authorizes a reinstatement of parental rights, and I think this is a bill it's certainly a big change, and it may have some unintended consequences. The question that's been submitted is, if a parent agreed to an order terminating the parental rights as set forth in 161.001. So for example, I think this question is contemplating, let's say, a mediated settlement agreement where a parent agreed that, let's say, there was sufficient evidence for the O ground determination and agreed to a mediated settlement, agreeing to termination based on that O ground. The question is, would that qualify as involuntary termination of parental rights, or would that qualify as voluntary termination of parental rights to allow for reinstatement after termination? And what I will say is, I think that's an excellent question that I don't have an answer for right now. I think that is a very open question that is something that's going to have to be sort of worked out through case law and as this bill develops over time. But I think right now, I think that's certainly a very good and very open question. Let's see what other questions that we have. One question we have, again, is regarding the reinstatement provision. The question that's been submitted to us is, if parents' rights are reinstated, is the child placed immediately back with the parent? That's not exactly clear. I think that's probably certainly the presumption, but it doesn't necessarily rule out that a parent's rights could be reinstated as a joint managing conservator or as a possessory conservator. It doesn't actually require that the parent's rights be reinstated as sole managing conservator. So that's, again, a really excellent question that I think is something that's going to have to be worked out over time. But the bill doesn't specify sort of the level of conservatorship once a parent's rights are reinstated under that provision. We have another question regarding Senate Bill 1896. And it asks, will the 6 months post-licensing requirement for PCA eligibility be counted from the date of the provisional license? I think that's probably the intent of that bill, to allow the licensing process to begin much, much earlier, to allow, hopefully, for people to be eligible for PCA. Whether or not that's completely consistent with some of the federal requirements is something that's going to have to be looked at. But as far as I think the intent of the bill, I think the intent of the bill is certainly to move forward as early as possible in time to allow relatives to start getting licensed. And I think it's important to note that was sort of a consistent theme we saw in a lot of these bills. There's a lot of interest in making sure relatives have appropriate information about their options as early as possible and can begin that licensing process as early as possible so that they are eligible for PCA when that issue comes to a head at sort of the end of the case. And we do have a question as to why the legislature got rid of non-emergency removals. You know, it's sometimes tricky to read the mind of the legislature, but as I kind of emphasized earlier, I think that removal has to be read in conjunction with the changes that were made to the court-ordered services statute. I don't think it's appropriate to view those separately. That was part of the same bill, and I think there was certainly a vision for how these cases that would proceed that includes both of those options. So I think that bill definitely sort of reoriented the different options that DFPS has regarding pursuing child safety, and I think those two things have to be viewed together. So As far as exactly why the legislator made that choice, I can't comment, but I do think it's important to view the bill in its totality. We have another question that's regarding whether or not a petition to reinstate parental rights may be heard by an associate judge or a district court. I will have to go back and look at the bill, but I don't believe the bill addressed that one way or the other. So my guess is that the same sort of benefits and drawbacks to a proceeding in front of an associate judge for most proceedings would also apply to that proceeding, but there wasn't any specific requirement that it had to be one or the other. I think, let's see, what other questions do we have?
Dylan?
Yeah, sure.
There was one request for clarification on, while we're on reinstatement on 2926, if it has to be filed after 2 years or within 2 years of termination. Can you just clarify the time frame for that?
It's after 2 years. So yes, not filed within 2 years of termination. It has to be filed 2 years after termination. Now, the open question is how an appeals process factors into that. Does that mean 2 years after the final order? Can a parent challenge the appeal and take the appellate process all the way to the end and then file a petition for reinstatement after the appellate process is done if that 2 years has expired? That's a little bit of an open question. We don't quite have clarity as to how those two things are going to work together. But yes, the petition, you have to wait 2 years after termination to file that petition for reinstatement. Let me see if we have any other questions. We do have some questions regarding funding, and unfortunately, we don't have time to cover that in this bill. It's something that is, to be honest, out of my wheelhouse. We track a lot of bills at the commission, but the funding issues are something that we try to focus on bills that affect the practice of attorneys who are representing children and parents in these cases. So while funding is something that's obviously relevant, it's not something that we track as specifically as we track a lot of the bills that affect legal procedure and other arrangement directly. So I can't unfortunately comment on a lot of the funding questions. Let's see if we have any other questions. We do have a question of what are the consequences if DFPS does file pleadings that do not comply with the provisions in the Civil Practice and Remedies Code as highlighted by 567. And I think the emphasis of that provision is that those cases shouldn't be treated any differently than any other cases. That if you feel that pleadings are not in compliance with the legal requirements, that CPS cases are not an exception to that. So I'm not going to say that there's an intention one way or the other, but I think the focus is that there's not a special exemption for CPS cases, that the rules and the consequences of those rules apply equally to CPS cases as they do to all civil practice. And I think there's a good question regarding the limit, the tolling limit on the deadline when trials has started. There is a question of how long the limit of the good cause exception can be. There was actually a little bit of disagreement in some bills that were filed this session. One bill that addressed this issue had a specific length where the extension could be no longer than, I think, 30 days. That bill did not make it all the way to the end. There was a separate bill that also addressed that situation that simply said the extension has to be a specific length of time. That was the bill that eventually got turned into law. So whether or not there is a specific length of time for that extension, the legislature clearly sort of had mixed feelings about that, but the bill that ended up passing did not require a specific length of time for that extension in those cases.
Dylan, we have two questions on right to counsel for reinstatement procedures. Can you address that?
I can, and there is no right to counsel for reinstatement that's included in that bill. The right to counsel was enhanced in this session, mostly towards court-ordered services cases. But as far as the reinstatement of parental rights, there's no right to appointed counsel. The counsel for the attorney. Now, I do want to say, the provision can be filed by a court-appointed attorney, but it has to be the child's attorney. That it's not just I want to emphasize that reinstatement of parental rights is not restricted to parents pursuing that legal avenue. DFPS can pursue it. The attorney ad litem for the child can pursue it. The single source continuing contractor can pursue it. So other entities other than the parent can pursue this avenue, but no, the bill does not have any sort of triggering mechanism that would establish a right to counsel for a former parent to have an attorney assist them with this provision. It's something that they're going to have to either do pro se or find an attorney who's willing to help them file that reinstatement.
Okay, well, I think that concludes our Q&A section of the presentation. And I want to thank absolutely everybody who attended this presentation, whether you're watching it live or via archive. Thanks again to Dylan and Amy and the Children's Commission team for making this possible. Please continue to send any unanswered questions to children@txcourts.gov. We are learning as we go here, as we move into implementation phase of these bills. Thank you for tuning in, and take care and stay well. We appreciate you very much. Look out for an announcement for the archived